for the following reliefs. I have reproduced the reliefs in the body of the judgment, so I will skip reading the reliefs. I think due to time factor, I will speak all the preliminaries. I will skip the summary of the cases of the parties, the evidence given, and the evidence on cross-examination. I will skip reading all that one. On the submissions of the defendant formulated only a single issue for determination. It has been reproduced in the body of the judgment. J. Williams appeared on the adoption. He adopted the final written address and argued based on sole issue. So the argument of counsel has been reproduced in the body of the judgment. The claimant's counsel formulated 3 issues. The 3 issues have been reproduced in the body of the judgment. Mr. M.B. Athed was the counsel that argued on the day the adoption took place. I have reproduced the argument of counsel, both oral and written. Then I'll go to the decision of the court.
As the court, please.
I have carefully considered the processes filed in this suit, as well as oral and written submissions of counsel for both sides canvassing the respective position of the clients. From the pleadings and evidence before the court, the main grounds of the claimant centers on the defendant's reliance on the alleged act of misconduct of 2012 and 2013, 2012-2013 as the basis to unlawfully terminate his appointment, when at no time was the claimant informed or notified in writing of any sitting by the staff disciplinary committee in which he was required to appear and answer the allegations made against him, and that he was not afforded the opportunity to be heard or hear the said Husseini Adamu, whom the first defendant had made claim that he gave the examination papers or booklets for marking. The claimant instituted this suit purportedly to challenge his disengagement from service of the defendant based on the ground that the procedure laid down for the taking of disciplinary action as stated in the Modibo Adama University of Technology Yola Conditions of Service for senior staff on the 6 to 15, which was tendered and submitted as the CW3J was not followed, and also that he was not given fair hearing. According to the claimant, the stoppage or non-payment of his salaries, allowances, and other entitlements by the defendant by reason of termination of his appointment on ground of misconduct are altogether illegal, null, and void. The claimant's letter of employment and that of termination of appointment were tendered and admitted in evidence as exhibit CW31, CW3A 1 to 2, and CW3G. The claimant is contending that the termination of his employment by the defendant should be declared null and void and of no effect whatsoever due to non-compliance or adherence with the provisions of the rules regulation governing the employment of senior staff of the university. The defendants on their part have maintained that due process was followed in terminating claimant's employment as provided by the regulation governing the condition of service of senior staff of the first defendant. The claimant had his employment with the defendant terminated after payment of 3 months' salaries in lieu of notice, and that the claimant accepted the termination and the payment in lieu of notice. Thereafter, took up appointment in Taraba State University, only to return after 2 years to file the present suit, complaining of his termination in the court. The defendant further stated that the claimant is stopped from complaining against the termination, having conducted all his clearances successfully and even receiving his 3 month salary in lieu of notice. The defendant further stated that the claimant was duly notified of the various sittings as the respect of the standing committee on cases of forgery of degree, statement of result, and related cases, where he appeared on the 10th day of November 2015 and interacted with the committee Furthermore, the defendant testified that the claimant had admitted to the committee that he did not mark the student's script, rather he gave them to one Hussein Ahmed, former student of the first defendant, to mark the state scripts. It is up to first and foremost ascertain the status of employment of the claimant with the defendant. It is certain law that there are three categories of employment in this country. One, those regarded as purely master and servant. Two, those where a servant is said to hold the office at the pleasure of the employer. And three, those where the employment is regulated or governed by statute, which is often referred to as having statutory labor. See the case of Olanian versus University of Lagos. See also Olarewaju versus Apri Bank. See also CBN versus Iguilo, where the Supreme Court explained that an employment is said to have statutory labor when the appointment is protected by statute or laid down regulations made to govern the procedure for employment and discipline of an employee. When an employment is found to have statutory labor, the employee in essence enjoys a special status, which is beyond that of the master and servant relationship, and in order to discipline that person, the procedure created by that statute must be followed. See the case of University of Ilorin versus Abe. See also Kule versus Osisen Apri Bank, Kule Osisen versus Apri Bank Nigeria PLC. See also Controller General of Custom and others versus Guso. In this case, the claimant was employed by the Council of the Federal University of Technology, Yola, now Modibo Adama University of Technology, Yola, by the exhibit CW3A12 as graduate assistant in the Department of Economics, where he rose to become lecturer one by promotion as contained in exhibit CW3B. The second defendant who employed the claimant was established by the Federal University of Technology Act, which was Decree number 13 of 1986, as amended by Decree 37 of 1990 and that of 1993. The second defendant is tasked with the responsibility to employ, promote, control, and discipline members of staff of the first defendant. The second defendant pursuant to the provisions of the Decree number 13 of 1986 as amended made CW3J, the Modibo Adama University of Technology, Yola conditions of service for senior staff 26 to 15, which came into force in September 2014. The Federal University of Technology, Yola was renamed Modibo Adama University of Technology, Yola in year 2019. The law renaming the Federal University of Technology, Yola is Modibo Adama University Act of 2019. This means as at the time the cause of action arose in January 2016 when the employment of the claimant was terminated, the applicable law to the employment of the claimant remained the Federal University of Technology Decree number 13 of 1986 as amended and exhibit CW3A122 letter of appointment and exhibit CW3J the condition of service for senior staff of the first defendant. The claimant having been employed by the second defendant as an academic, his employment is governed by the provisions of Federal University of Technology Act, now Decree 13 of 1986 as amended, which by the section 15 of the said act has made ample provisions on procedure for removal of an academic staff of the first defendant. The Federal University of Technology Act, Decree 13 of 1986 as amended, made provision for employment, promotion, and discipline of the claimant. It is interesting to note that the Modibo Adama University of Technology Act of 2019, which was enacted to effect the renaming of the name of the first defendant, contains similar provisions with those of the Federal Universities of Technology. In fact, the provisions are the same. the provisions on employment, promotion, discipline of members of staff. A careful perusal of the provisions of the Federal University of Technology Act as amended clearly shows that employment as an academic or administrative staff fall within the category of employment that can be categorized as having statutory labor. In coming to this conclusion, I took a holistic view of Exhibit CW3A1 to 2, Exhibit CW3J, and the provisions of the Universities of Technology Act, University Act as amended, pursuant to which the claimant was employed by the second defendant in exercise of the powers conferred on it by the Federal Universities of Technology Act as amended. This is because in determining the question of whether an employment has the statutory labor or not, the court must look at construction of the contract and the relevant status. See the case of Ojabo versus Minister of Communication and others. In the case at hand, in that case, the Court of Appeal affirmed what has been the law. Thus, a contract of employment enjoys statutory labor where its conditions are governed by the provisions of statute or regulations derived from statute. The court went further to state that the mere fact an employer is a creation of statute, or that is statutory corporation, or that the government has shares, does not elevate the employment status into one of statutory labor. Rather, there has to be a linkage or nexus between the employee's appointment with the statute creating the employer or corporation. See the case of Pakwade versus Obafemi Awolowo University Teaching Hospital, and the case of Controller General of Custom and others versus Gusau Supra. Additionally, an employee who claims wrongful termination of his employment with statutory protection must prove the following material fact. 1, that he is an employee of the defendant. 2, the terms and conditions of his employment. And 3, the way and manner by whom he can be removed. See the case of Ujam versus IMT. See, in the case at hand, the claimant is relying on the provisions of Exhibit CW3J to press home his claim. It is also clear that the claimant in this case, by his employment as per Exhibit CW3A1 to 2, and the provisions of the Federal Universities of Technology Act, his employment is clothed with statutory labor. The provisions of the law which establishes the defendant and clothes them with power to employ, promote, and discipline the employee clearly invest the employee with a legal status, a status which makes his relationship with the defendant to certainly go beyond the ordinary or mere master-servant relationship, which is the case in this case. The claimant employment was pursuant to Exhibit CW of the law as amended. This is because the employment was in the exercise of the powers of the second defendant as contained in the law establishing it. This means the employment is protected by statute. See also Federal Capital Territory Development Authority versus NAIB. See also CBN versus Ubilo. See also Controller General of Custom versus Gusau Supra. My finding on status of the claimant's employment with the defendant is in line with the Supreme Court decisions in a plethora of cases, to the effect that for an employment to be deemed one with statutory labor, it must have statutory enforcement, or at any rate be regarded as mandatory. In the case at hand, the employment of the claimant has statutory backing and it has nexus with the law establishing the defendant. See also Olande University of Lagos, Epereku versus University of Lagos, Bamboye versus University of Ilorin, UMTHMB versus Dawa, Shitabe versus Federal Civil Service Commission, Archibong versus Archibong Udo versus Cross River State Newspaper Corporation. See also Mrs. Pakwade versus OAU Teaching Hospital, and host of other cases that have been reproduced in the body of judgment. The term statutory labor simply means covered by statute. Thus, an employment will be taken as enjoying statutory labor once it is covered by, or governed by the statutory provisions in every material particular as to appointment of the employee, termination, dismissal, and other sundry conditions. See the case of Adegoke versus Osun State College of Education. The claimant's employment has satisfied all these criteria, therefore it qualifies as employment that has statutory backing, thereby elevating it above ordinary master and servant relationships. Having found the claimant's employment to be one less with statutory labor, for the defendant to discipline the claimant, they must do so in compliance with the laid down procedure for removal of claimant as stipulated in the statute and other conditions of service, which must be in conformity with statute establishing the office of the claimant, i.e. the law establishing the defendant. It is only when the action of the defendant is carried out in compliance with the statute that the action can be sanctioned and approved by the court. The law is settled that the only way to terminate a contract of service with statutory labor is to adhere strictly to the procedure laid down in the statute. See Bamboy versus University of Ilorin, see Olatu Bosun versus NISA, see Iderima versus River State Civil Service Commission. As pointed out earlier in this judgment, Section 15 of the Federal Universities Act Decree of 1986 as amended is imprimaterial with the provisions of Section 16 of the Modibo Adama University of Technology Act. This means that the procedure for discipline in the two laws are same. With the finding that the claimant's employment has statutory labor, this means for such employment to be determined, the provisions of the statute regarding the determination of employment must of necessity be terminated or determined in the way and manner prescribed by the relevant statute, and any other manner of determination inconsistent with that of the statute prescribed would be null and void and of no effect. See Iderima versus River State Civil Service Commission, Supra, see Imoleme also versus WAEC, see Olande University of Lagos, and host of other cases. Employment that has statutory labor can only be terminated in the manner allowed by the very statute that provide for it. See Osisen versus Apribank, see Bamboye versus University of Ilorin. The only way to terminate a contract of service with statutory labor is to adhere strictly by the procedure. The grounds of the claimant in this case, as pointed out earlier in this judgment, is that his employment was terminated by the defendant based on incident of 2012-2013 without notifying him in writing of the offenses he committed or formally inviting him to appear before any committee to defend the allegations. Also, OPES said Hussein Adamu that was alleged to have been given examination booklets to mark. The defendant in their defense stated that the claimant employment was duly terminated as he was paid 3 months' salary in lieu of notice, which he accepted and did clearance. Claimant is stopped from challenging the terminations of his employment by the defendant. The defendant also stated that the claimant has appeared before the disciplinary committee for interaction. Let me quickly say here that Let me the defendant regarding the payment of 3-month salary in lieu of notice is faulty in the sense that you can only terminate on payment of salary on notice for a statutory employment when there is no allegation of misconduct against the employee. In the case at hand, the defendant have alleged misconduct against the employee. Therefore, they cannot pay 3-month salary in lieu of notice as to determine the employment of the claimant. They must undergo the processes and procedures as provided by the statute in terminating the said employment. See the case of Olanion versus University of Lagos, where the Supreme Court made it clear that for an employment with statutory labor to be determined, it has to be based on misconduct. The employee must undergo the process of discipline and not mere payment of salaries in lieu of notice, as it was done to the case in Olanion versus University of Lagos. The defendant has also made heavy weather on the claimant acceptance of the 3-month salaries in lieu of notice as evidence of compliance with due process in terminating the claimant's employment. They also stated that by accepting the 3-month salary in lieu of notice and clearance conducted by him, the claimant has waived his right to challenge termination of his appointment by the defendant. I shall now consider whether the acceptance of 3-month salary paid to the claimants by the defendant has precluded the claimant from complaining about his termination of his employment. It is right to know that in employment governed by the common law or agreement of the parties that has no statutory backing, where employee accepts salary in lieu of notice of termination of his employment, he may not be heard to complain later that his contract of employment was not validly or properly terminated, because in such a case, his conduct could render the determination mutual. See the case of Julius Berger, Nigeria Limited versus Unwagu. See also versus Unwagu, reported in 2006, 12 Nigerian Ukulele Report, part 995, page 518, where it was held that where an employee receives his terminal benefit after his employment is brought to an end, he cannot be heard to complain later that his contract of employment was not properly determined, because the acceptance of payment by the employee renders the determination mutual. In Ilo Bachi versus Phillips, reported in 2002, 14 Nigerian Ukulele Report, part 181, it was held that the appellant had acquiesced in the determination of his appointment and cannot thereafter be heard to complain or challenge his termination because of the collection of his entitlement has led to rest any contract, real or imagined, between the parties. Also in Angel Shipping Limited versus Aja, reported in 2013 Nigerian Ukulele Report, part 685, it was held that having accepted 1-month salary in lieu of notice, the contract was validly and properly determined in accordance with the terms and conditions prescribed in Exhibit 1, the contract of appointment. However, in the Supreme Court case of military administrator of Benue State versus Ulege, reported in 2001, 11 Nigerian Ukulele Report, part 141, page 194, it was clear publication entrenched that where an act is void ab initio, it cannot be validated by subsequent act, even if valid, because one cannot add something to nothing. It was stated that this retirement remains void, notwithstanding the acceptance of 3-month salary in lieu of notice. Karidwaya JSC of blessed memory stated that I am satisfied, therefore, that the acceptance by the respondent of the 3-month salary in lieu of notice of retirement did not amount to acceptance of the invalid and void retirement. His lordship also referred to Adeni versus University of Lagos, reported in 1993, 6 Nigerian Ukulele Report, part 300, page 426, where the Supreme Court equally held that the appellant's application for a collection of 3-month salary in lieu of notice of retirement did not render valid the invalid and void act of unlawful and wrongful retirement. It is now well settled that where an act is void, it cannot be validated by subsequent acts, even if valid. This is because you cannot add something on nothing. See the case of UAC Limited versus McCoy. In the light of the foregoing, the decision of the Supreme Court, the defendant in this case cannot rely on acceptance of 3 months' salary in lieu of notice to defeat the claimant's challenge of termination of his employment before the court. It is clear as crystal. It is clear in the light of the foregoing Supreme Court cases that the defendants are not allowed to claim that the claimant, by accepting 3 months' salary, has waived his right to challenge the termination of his employment. Therefore, acceptance of salary in lieu of notice of termination cannot be a bar to challenging of termination of employment with statutory labor. It is right law that an employee claiming or seeking for voiding of termination of his employment must be able to convince the court by establishing that the termination of his employment is unlawful. This burden is discharged by the employee by proving that he is employee of the defendant, the terms and conditions governing his employment, who can appoint and who can remove him from service, in what circumstances the appointment can be determined by the employer, and how the terms or conditions of service were breached. See the case of Okomu Oil Palm Company Limited versus Ise Rehen, reported in 2001, 6 Nigerian Kulolo Report, part 710, page 660. See also Emokfae versus University of Benin, reported in 2000, Nigerian Kulolo Report, part 795, page 139. See also Amodu versus Amode, reported in 1995, Nigerian Kulolo Report, part 150, page 356. See also Adeniran versus Nepa. See also Olatumbosu, Oloruntoba Oju versus Abdurrahim, 2000, Nigerian Kulolo Report, part 1157, page 83. I have in the earlier part of this judgment found that the claimant's employment enjoys statutory labor. This means the terms and conditions of service governing the employment of the claimant are specifically provided for in the statute or regulation made thereunder. With the above finding, I am now saddled with the task of considering whether the procedure adopted by the defendant in terminating the claimant's employment or services has followed due process of law as encapsulated in the statute in investing the claimant with statutory labor. To put it differently, whether the applicable statute and conditions of service or regulation governing the employment of the claimant were duly complied with by the defendant in terminating the claimant's employment. This is because in determining contract of employment with statutory labor, the letters of the law must be followed and obeyed, as any infraction or non-adherence to the procedure laid down will render the exercise resulting in termination null and void and of no effect whatsoever. See Adeni versus Governing Council, Yaba College of Technology. See Olanian versus University of Lagos. Section 15 of the Federal Universities of Technology Act, Decree number 13 of 1986 as amended, has made ample provisions for disengagement of a member of staff of the defendant who is an academic, like the claimant in this case. Sections read as follows. I hereby reproduce. I will skip reading the provisions. Counsel will read when they get the hard copy of the judgment. I also reproduce the provisions of Part 2, paragraph 2.25 on cessation of employment as contained in Exhibit CW 3J, that is the conditions of service. So I will also skip reading that provision. It is clear from the above provisions of the law and the conditions of service, Exhibit CW3J, that the power to exercise disciplinary action on any member of staff of the defendant who is an academic like the claimant in this case is vested in the council of the university, i.e. the second defendant. The claimant has insisted that the defendant did not comply with extant laws and regulation in terminating his employment, while the defendants maintain that due process of law was followed in determining the claimant's employment. As the claimant has appeared before the committee and his termination was by the counsel of the second defendant, in order to determine whether there is compliance with due process, it is apt at this juncture to examine the evidence relied on by the parties in proof of their respective position before the court. The letter of termination is Exhibit CW3G. For proper appreciation, I shall reproduce the content of the said exhibit here under, and it reads, the heading, Modibo Adama University of Technology, Yola, in bracket, bosses, Office of the Registrar, Establishment Division, Academic Matters, PMB 2076, Yola, Adama State, Nigeria. Then it goes on to provide the name of the registrar and the date. The letter was dated 21st day of January 2016, and it was addressed to Saidu Adamu, the claimant in this case, of Department of Accountancy, School of Management and Information Technology, Modibo Adama University of Technology, Yola. And the heading is termination of your appointment with the university. The content read as follows. This is to inform you that the University Management Committee at its 97th 2016 deliberated on the report of Staff Disciplinary Committee on a case of misconduct level against you where you admitted assigning the marking of examination booklet 412, planning and control to be a course allocated to you in second semester of 2012/2013 academic session to one Husseini Adamu, a former student. You are acting by paragraph 17 of the rules and regulations governing the conditions of service for senior staff of the university is misconduct, and prejudicial to the good name and reputation of the university. In the light of the above, and by paragraph 8.12H of the rules of regulating the conditions of service staff for senior staff of the Modibo Adama University Teaching Hospital, the University Management Committee directed the termination of your appointment with immediate effect. Hence, your appointment with the university is hereby terminated with immediate effect. Based on the above, therefore, the purser is directed to pay you 3 months' salary in lieu of notice, and you leave immediately. Similarly, he is to compute your entitlement, less your indebtedness to the university, if any. You are therefore expected to hand over university properties in your possession to the head of Department of Accountancy. You are also expected to submit clearance letters from your department, bursary, works and maintenance, medical and health center, university library, as well as your identification card to the establishment secretary to enable us process your final clearance. On behalf of the Vice Chancellor and the university management, we thank you for the services you have rendered to the university and wish you the best of luck in your future endeavors. Thank you. Signed, Alhaji Ibrahim A. Ribadu, Registrar. The defendant relied on Exhibit DW1A122, Exhibit DW1B, Exhibit DW1C, Exhibit DW1D to support their position that the claimant appeared before the disciplinary committee and the employment of the claimant was duly terminated by the defendant. However, a combined reading of these exhibits relied by the defendant clearly proved the opposite of what they asserted. On Exhibit 3 CW3G, letter vocally clear that the University Management Committee at its 90th regular meeting held on Wednesday, 6 January 2016, deliberated on the report of Staff Disciplinary Committee on a case of misconduct labeled against the claimant, where the claimant was purported to have admitted assigning the marking of examination booklets in respect of post AC 412 allocated to him to one Mr. Husseini Adamu, a former student. The action of the claimant was said to have amounted to misconduct contrary to paragraph 1.7 of the condition of service, exhibit CW3J. Consequently, the University Management Committee directed the termination of the claimant's employment with the university with immediate effect. The content of exhibit CW3G clearly violates the extant provisions of Section 15 of the Federal University of Technology Act, Decree 13 of 1986, as amended, as well as the provisions of paragraph 2.25b of exhibit CW3J. The conditions of service as termination was not done by the second defendant. Exhibit DW1C and exhibit DW1D, which were exhibit tendered and admitted in evidence by the defendant, has confirmed the position taken by this court that the termination of the claimant's employment was not done by the second defendant as required to be done by law. This infraction has rendered the termination of claimant's employment null and void and of no effect whatsoever, as it was not done by the authority vested with the power to do so, i.e. second defendant. Exhibit DW1C is a memo written by the Deputy Registrar of the University to the Registrar of the University, stating that the second defendant at his 83rd regular meeting held on Saturday, 14th of April 2016, considered and approved management decision that terminated the appointment of the claimant with effect from Wednesday, 6th of January 2016. What this connotes is that the second defendant is a rubber stamp of the university management. This is a clear abdication of statutory duty, which is the law imposed on the second defendant. Therefore, the approval of the decision of the University Management Committee terminating claimant's employment by the second defendant as per exhibit DW1C by payment of 3 months' salary after the purported termination. Sorry, terminating claimant's employment by the second defendant as per exhibit DW1C 3 months after the purported termination by the University Management Committee is an illegal thing, unlawful, null and void, as there is no provision in the law governing the defendant delegating the power of the second defendant to be exercised by the management by the University Management Committee. See the case of Bamboshe versus University of Ilorin, where the Supreme Court made it clear that the function of the council cannot be delegated to any person. The council cannot therefore abdicate its function and allow the university management to take a decision on its behalf, only for the council to ratify or to approve what has already been done. It is also clear from exhibit DW1C and exhibit CW3G that the termination of claimant's employment was with immediate effect from 6th of January 2016, the day the its 97th regular meeting. The claimant was notified of the termination by the exhibit CW3G on the 21st day of January 2016. This means that the termination was retrospectively made, since the claimant was not notified on the 6th day of January 2016, the effective date of the termination. It is right to know that termination of employment cannot be made retrospectively. It can only be made with immediate effect or in future. This act of the defendant goes contrary to law and renders the termination null and void, and goes to support lack of following due process in the exercise of disciplinary power over the claimant by the defendant. By the exhibits DW1D, the Vice Chancellor of the first defendant wrote to the chairman of the second defendant, intimating the second defendant that the university management at its 97th regular meeting held on 6th day of January 2016 has considered a report of staff disciplinary committee on case of misconduct leveled against the claimant and accepted the recommendations of the and terminated the appointment of the claimant and paid him 3 months salary due of notice. This clearly shows that the chairman of the second defendant is only being informed of the decision already taken and implemented by the governing council. The content of exhibits DW1D clearly has supported the case of the claimant that he never appeared before any disciplinary committee or given opportunity to exculpate himself or been given opportunity to ask the person that was alleged to have been given examination booklet for marking. It is clear from exhibit DW1D that the approval of the second defendant was based on the memorandum of the Vice Chancellor and not the report of even the disciplinary committee, which was never laid before the second defendant. This is a clear violation of the claimant's right to fair hearing, as it is only the second defendant that has the power under Section 15 of the law to terminate the appointment of the claimant. Exhibit DW1B, the minutes of the staff disciplinary committee meeting clearly shows that the witnesses that testified or interviewed by the committee testified and give their evidence in the absence of the claimant, as the report clearly shows that the claimant was not available on those dates when those witnesses who testified. The same scenario repeated itself with respect to investigation conducted in rest of exhibit DW1B. The claimant was not allowed to put questions to those who testified during the investigation against him, as they were separately interviewed by the committee. In fact, in the defendant's submissions, it was clearly stated that the claimant interacted with the committee. This means that the claimant was never in allegations leveled against him, and he was not before the committee to defend himself against any allegation. It is clear from exhibit CW3G letter of termination that the claimant was accused of giving one Hussein Adamu examination booklet for marking, while exhibit DW1A and DW1B clearly shows that the person who appeared before the committee was one Hussein Ahmed and not Hussein Adamu. And despite this glaring discrepancy, the defendant did not make any effort to amend their process if it was a mistake regarding the name. Since I do not have any evidence to show that Hussein Adamu is one and the same Hussein Ahmed, I come to the conclusion that the committee did not even interview the person that was alleged to have given examination booklet for marking by the claimant. This is a great omission on part of the defendant and a fatally one. In fact, the defendant have not even called the person to testify in the course of the trial. The claimant had insisted that he never appeared before any disciplinary committee, as he was never informed of the allegation leveled against him, and he was never allowed or given opportunity to question his accusers. All the assertions of the claimant have been established by exhibit DW1A, DW1B, and DW1D, which were exhibits that were tendered by the claimant, by the defendants themselves. I quite agree with the claimant that he was not afforded opportunity to defend himself, and he was never notified of the allegations leveled against him, as there was no such evidence before the court. If the defendants have really notified the claimant, they would have tendered evidence of such notification of the allegation against the defendant. In the absence of such evidence, I have no choice than to believe the claimant that his right to be heard by the council or the committee set up by the council has been breached. All that the council did was to rubber stamp what the university management committee has done, which is illegal. This practice is against the well-established procedure for discipline of an academic staff of the defendant like the claimant. In this case, the termination of the claimant, therefore, is null and void and of no effect. I hereby nullify the letter of termination, Exhibit CW 3G. It is hereby set aside. On appointment with Federal University of Kashere, the defendant did not adduce any concrete evidence to prove that the claimant is employed with the claimant has taken appointment with Taraba State University, but the claimant has, in the course of cross-examination, admitted taking a part-time teaching job with Federal University Kashere in Gombe State and not in Taraba State, as was stated by the defendant, and that was in July 2019. Also, one of the witnesses of the defendant, CW1, has under cross-examination stated that the claimant, after he has been sacked has taken a teaching appointment with University Kashere, Gombe State. The evidence of CW1 and that of the claimant tallies that he was engaged by Federal University Kashere, but the evidence is that he was engaged as part-time teacher in July 2019. This therefore means that if the claimant is to claim any payment of entitlement, salaries or entitlement, the period for which he served with the Federal University Kashere must be excluded. For avoidance of doubt, having found the termination of employment null and void, I hereby ordered as follows. 1, a declaration is hereby granted that the termination of claimant's appointment as per Exhibit CW1G is illegal, null and void. 2, a declaration is hereby granted that the stoppage or non-payment of salaries and other entitlement of the claimant by the defendant by reason of termination of his appointment on ground of misconduct are altogether illegal, null and void, and of no effect. The defendants are hereby ordered to immediately reinstate the claimant to his position as lecturer 1. The defendants are hereby ordered to pay the claimant salaries and allowances and other entitlement from the date of purported termination of his appointment to date and subsequently till his service are lawfully determined, excluding the period he served with Federal University Kashere. The defendants are to pay the claimant the sum of 500 naira cost. The claimant is hereby reinstated with immediate effect. All the orders made are with immediate effect. This is the judgment of the court. Judgment is entered accordingly.
As the court pleases. We thank my Lord for the judgment just delivered. We are really grateful.
Yes, Mr. Odo, you are welcome. Yes, registrar, call the next case.
Suit number.
Thank you, Mr. Udo.
Suit number NICS
Thank you very much,
2016 between 1 Engineer Asupobasi. 2.
Yes, we have come to the end of the virtual sitting. The administrator, you can discontinue the sitting.
Suit number